I didn't ask about it.
Good evening. It's December 19th, and we're back to the public session of the Township of Chatham Township Committee meeting. And now we're going to have an update regarding the Affordable Housing Litigation Case Management Conference from our counsel, Albert Cruz. Albert, please go ahead.
Good evening, Mr. Mayor.
Good evening.
As you know, on this Tuesday, December 17th at 4 o'clock in the afternoon, there was a case management conference with the Superior Court judge overseeing this case. The participants in the conference was the attorney for Fair Share Housing, the court-appointed special master, the attorneys for the Dixie-Dale Arbor Green development, along with the township planner and myself. It was a detailed conference with the judge asking many questions regarding the status of the town's plan, including the township's requests for an extension within which to reach compliance. As you recall, the township at the December 12th meeting adopted a resolution explaining the reasons and a timeline for the extension. The judge did not grant that request, but ordered that the township make a formal request for an extension to the Superior Court and laid out a briefing schedule and a hearing date for that motion. And so by January 10th of 2020, the township has to submit a motion seeking an extension with any and all supporting papers. By January 24th, 2020, Fair Share Housing will have to file any opposition and any cross motions. By February 7th, the township will reply to the Fair Share Housing Center opposition and cross motions. By February 12th, this court-appointed special master will review the submission of all of the parties and present the report to the court regarding his recommendation regarding an extension, and there will be a hearing before Judge Michael C. Gauss on February 14th, 2020 at 1:30 in the afternoon, and at that point he will hear the motions and any cross motions and render a decision. The judge did extend the township's immunity from builder's remedy lawsuits until February 14, 2020. That is the procedural status of the case. What my advice to you is that you continue to look at the alternatives and the alternative sites and continue to show good faith to the court during this almost two-month period to continue to work to fulfill your obligation under the settlement agreement and your constitutional obligation.
Okay, great. Thank you, Counsel. And at this point, I am going to ask Deputy Mayor and also Liaison of Affordable Housing for the Township Committee to give us an update, give you an update as to what has been taking place with the committee and our work. And Mike, please, go ahead.
Thank you, Mayor. Building on what our attorney reported back to us from the courts, we also are in agreement that we need to move forward and continue to work toward the best solution that we can for meeting our affordable obligation. And in trying to give some direction and guidance to our professional staff, what we are doing is narrowing our focus a bit so that we can put our efforts into the particular sites that look like they're the most feasible and to going forward. So these are by no means a selection process. This is just guidance from us to our professional staff to identify a number of sites that they can put their attention into. All of these, there are certainly the details are not here, and I appreciate the interest of the people who are here tonight looking for details. But in order to get that, we need to start to drill down deeper with the help in some cases, of outside consultants and specialists. So this is the first step toward identifying the sites and gathering that information so we can move forward intelligently. And the sites that we are going to be focusing on going forward will be we're going to continue to look at this site and see what that would mean. We're going to continue to look at the skate park / police department site and try to fine tune our information about that. We know that our total obligation is close to 100 units. So continuing on to try to supplement those sites would be the River Road foreclosure site, which is the property on the west of the Cardinal Hill Apartments. We are looking at a property in Chatham Glen. It is in the vicinity of our sewer pumping station there. There is open space, and we are going to be exploring that as well. We are going to be taking a further look at the Tanglewood recycling / compost area, just to get some numbers that can attach to that and make an intelligent decision down there. And the township owns a lot at the end of Gibbons Place, and that is also on the table, most likely for a small group home, which is a special needs type occupancy. So those are the 6 locations that that we would describe as really being the active focus of attention as we go forward. And I know that everybody would like to have more details than that, but that's the step in the process that we're at tonight.
Thank you. Great update. Thank you, Deputy Mayor. And so now I am going to open the floor for hearing of citizens and petitions. And this is an opportunity for any member of the public to be heard about issues which are not topics of scheduled for public hearings tonight, to help facilitate an orderly meeting and to permit all to be heard. Please understand that you are limited, the public is limited to 5 minutes. So thank you very much, and I am sure. Yes. You know what? We're starting. Why don't you, Karen,
this
talk
is
about
just
that?
actually a public service announcement as opposed to being a member of the public, which I also am. If you saw this in your mailbox, it's not junk mail. Please do not throw it out. This is your 2020 recycling guide. It came out to all residents with a mailing address in Chatham Township. Please just keep in mind that it's got the dates for recycling, all the items that you can and ought not to be including in your recycling collection, and the hours of our Township Recycling Center. So thank you for indulging me. I did that as a courtesy to our dear friends at the Department of Public Works, which oversees our recycling efforts. So I thank you for allowing me to interrupt.
Thank you, Karen.
Thank you.
Okay, we're going back to hearing of citizens. So the floor is open for citizens to make comments, petitions. 5 minutes limited, everyone. Yes, please introduce yourself, although we know you.
Yes, hi, my name is Susan Hogue. I live at 76 Canterbury Road in Chatham Glen. I'm just coming to put something on the record. As a result of an Open Public Records Act request, we did get copies of 3 letters that were sent to the police chiefs back in 2015, 16, and 18, with copies to the mayors, which would have been Kevin Sullivan in 15 and Mayor Ritter in 16 and 18. They list the deficiencies at the police station, and I know there were a lot of questions at the last meeting about when did we first know. Obviously, sometime starting in 2015, there were members of either the administration, obviously the police, We've reached out to both police chiefs. We have not heard back from them. We will continue to try and get additional information, but I just wanted to let everybody know that I'm putting that on the record. Thank you.
Thank you, thank you. Appreciate it. Is there anyone else from the public?
Yes, Michael Oyen, 3 Hillcrest Avenue in Chatham. And I'd like to thank Committeeman Kelly for that good update on the sites being looked at. That's very promising and eliminated most of the questions I had. But one other issue I'd like to have addressed is what is going to be the open process by which we are able to, in a timely fashion, review the progress of the planning activities and perhaps give you some useful input. And is that going to wait until the first of the year when the new administration takes over? Or do you have any idea of how that's going to work?
At this point, I would assume that you would, next update would be with the new administration, and then
And we should look to them to establish the process.
then they will, I'm sure they will come up with a process to update public constantly.
What our-
Public, you want to
What our plan is to, and we've been working on this for hours of conference calls, and is to look at these. We heard what you said about multiple sites, about breaking it into smaller sites, looking at, continuing to look at a density of sites, and weighing all of those out in options that would be an A, B, C, possibly a D option, and looking at what those costs are going to be,
Right.
so that you all will know what the costs are, because there's an assumption that these smaller sites spread out will be more costly to the township.
Absolutely.
But we don't know what that's going to be and what everybody's temperature is going to be for what that's going to add to the tax burden. And then we're going to come back out as soon as we get those. There's already been a great deal of work with all of our professionals reaching out to the various, as Mike said, various professionals to get these costs. Come back with A, B, C, D. This is what it's going to cost the township. This is what it's going to cost in terms of tax dollars. And then present those to the public with the desire for feedback.
Okay, great.
And so as soon as we look at what our schedule is going to be, based on what we have with the judge, which really gave us a 2-month little bit of break in the action, with us still able to go back and try and get a continuance, our 4th continuance, that we'll be able to establish. We're going to have some sort of special meeting in between, because we meet for the reorg meeting, then we don't have a meeting until the 24th. So in some time frame there, we'll work out the time when we can get the most information, have these things laid out clearly, and then present them to the public for feedback.
Okay. I would just like to say that I found attending the Saturday morning meetings with Mike Kelly to be very useful. Mostly he's been educating us as to what the constraints are that you have to operate under, so it's been very helpful. And even if you don't have a formal procedure outlined until the middle of the month, I would hope that you might continue the Saturday morning sessions to help
I
us.
think we're going to do that, right?
We're on schedule to do it this Saturday.
This Saturday, right.
We're going to skip the next Saturday, the holiday
Right,
week.
right.
But this Saturday, 10:30, here at Town Hall.
And would you anticipate continuing them into the next year?
Um,
Or does that await the
Well,
formation of the new?
Yeah, let's take it a step at a time. I
Okay.
certainly have no intention not to, but let
Okay.
me make that commitment in another week or two.
Okay, thank you very much.
But I
Thank you.
think we do have to remind you that if it's news for public dissemination,
Oh, yeah,
the Saturday morning coffees
Yes.
would probably not be the best
Correct.
place to
Absolutely.
do it.
sure,
Right,
exactly.
would
Yeah, we
wanna do
understand,
it with
yeah,
a very broad base.
we understand that
Right.
constraint.
Thank you.
Great.
Next person, please.
Richard Matlaga, 36 Dale Drive. And please bear with me. I'm trying to understand this settlement and trying to read about it. So I read David Kinsey's report with so much statistics it'll blow your mind. And then Colleen O'Day ran an article that was called How New Jersey's Court-Approved Plans for Affordable Housing Work, which is interesting. It was a short article. But this was a negotiated settlement, I believe. It wasn't so this is a negotiated settlement, began in 2015, signed in 2018. When you read about affordable housing, it says settlements with the Fair Share Housing Center do not require a municipality to build, nor does it require you to provide the land. So it sort of gets confusing in my own brain as to why did we agree, and we're still going forward, to provide the land to build 98 standalone rental units. This is the equivalent of affordable housing of 650. If the developer built 650, he would have this number of affordables in it. And then we're going to hear later about the overlay zone, and it only falls into effect when the building happens. So why is this being forced on us to build? That's a question,
Okay.
yeah.
Okay, Al, could you please answer?
Well, is there a practical, I mean, you're probably going to give me a long legal reason, but is there a practical, 20-word answer?
Well, I think I've explained this to you before, and I think you complimented me once on my explanation by email.
Watch the video, is that what you're saying?
No, and I'll try it again and try to be as simple as I can. First, it was a policy decision of the Township Committee. And that policy decision was to mitigate the total number of units that would be built in the municipality. The best way to do that is to have an affordable housing development, 100% affordable housing development sponsored by the municipality. And that takes it out of the first category that you indicated. The first option is inclusionary development, where the developer gets a density bonus, meaning gets to build more units than they would on normally. In exchange for that density bonus, the property owner builds the affordable housing units. So it could be 6 units to an acre, 8 units to an acre, 10 units to an acre, or perhaps more. So you're limiting that multiplier, because when it's 100% affordable housing, there is no multiplier. You have 1 for 1. So if your obligation, let's say, is 100, and you use 100% affordable housing development, township sponsored, then that 100 is 100. It's not you don't have the multiplier. But because it's municipally sponsored, that means the municipality has the available land and is willing to contribute to the development in other ways. So the policy choice was 100% municipal development, municipally sponsored development, to limit increases in population, increases in school children, increases in traffic. So it's a trade-off.
It's a trade-off.
Correct.
But what the one assumption you had in there was the town has the land, and we're having difficulty getting that land. And
if I can address that, when there's a builder's remedy, the town loses control over the zoning. So for example, if you have 2.5-story zoning or 35 feet zoning, the builder can request that the court will say, here's your builder's remedy. You get to build X number of units on that property, affordable, figure out what how the density is and what it looks like.
And I go along with all that. Where I'm trying to get to is that when all of this negotiation was going on, the town said, yes, we can build these 98. They didn't have a site, but they said, oh, we probably have land. We find that we don't have land. And in the settlement, I don't see any compensation for environmentally sensitive land, wetlands. I don't see any compensation for that we may not have sewerage in the locations that we're getting, and that's an extra cost. So when Ms. Ness says, talk about the costs, it shouldn't be an open pit that we're asked to fund. It may be that during this go back to the court, it was we had the best intentions and we couldn't do it because we didn't have the land. Think about what we're doing. We're putting 24 units at the skate park. Now, these people, when they rent these units, have to sign an acknowledgement that they know that their unit is next to the Department of Public Works, the heavy equipment. They won't need an alarm clock. That beep, beep, beep of those trucks will wake them up every morning. They will have to provide a written acknowledgement that they're next to the police station. They'll have to provide a written acknowledgement that they're next to the gun range that's used during the day, on weekends, and in the evening hours. And you'd say, is that the place for affordable housing? Now, look, I am for affordable housing. It's allowing people to come into the community, get an education in Chatham schools, and improve their economic status, their well-being. They will develop wealth of sorts. But you need to make this successful. It needs to be that we have to assimilate them into our town. Segregating them in a location such as 65 here, or even the 24, is not assimilating them into the neighborhoods. And I think we have to be aware of that that's what we're trying to achieve also. Look at what they did in Madison. The one on Cook Avenue is affordable housing. It's 12 units. It's convenient to town. That's the spirit to me of this.
If I may, Mr. Mayor, I won't debate the spirit with you. That's a policy decision for the Township Committee. But you indicate that there is no available land. Let's put the settlement in the context of what was occurring at that time. And that was Dixie-Dale is one of several large parcels in town that can be developed. Dixie-Dale had the potential for a lot more units than the 53 that have been approved there. So and in fact, when the township rezoned that property, Fair Share Housing sued the municipality to set aside that zoning. And in their complaint, they believe that a minimum of 300 units can go on that property. So that settlement of the affordable housing litigation also included a settlement of the Dixie-Dale property. So there was available land at the time of the settlement. And that land was under development pressure. So there was vacant land, and there's other land that could be available for additional development. In addition to that, the skate park. The skate park has been an affordable housing zone for several decades, and it just was not utilized. Perhaps the Council on Affordable Housing did not pursue that, but when a developer sees that a municipality has an affordable housing zone, and it's not just a zone that sits there, it's a zone that is owned by the municipality, and the developer says, I want to build housing on your municipally owned affordable housing designated site, that's something that the municipality has to consider. So you need to put into context the pending litigation and the fact that the skate park and that property had been zoned for affordable housing for several decades. And so
A fair point.
you cannot segregate, or you cannot parse out all of these components, you have to look at it all in one bundle, and you have to look at what policy decision was made. So you can argue about a lot of the other things you said, but those were the facts that existed and still exist now and was a basis for the settlement.
And just
Yes.
10 seconds. But as you said, at the time that was available space, if Dixie Dale goes through, it is no longer available space. All I'm saying is there's limited space for the 74, and I think that is part of the argument why we may not be able to meet the 74, and I don't think that's a bad thing. My time's up. I hear it ringing.
You can finish your sentence.
No,
Okay.
it's just that I think that there's a lot that goes into this, more than just trying to find another location. It's time to step back and rethink. Times change, and look, deals change. And
Fair point.
Right?
Fair point. Anyone else from the public? Okay, I see, you're coming, okay. Please.
Doug Pitney, 54 Mountain View Road. In planning ahead to 2020, I think it would be a good idea for at least the Township Committee to think about their scheduling as it applies to, I'm probably not as much regular meetings. Are regular meetings set already for 2020, Greg? Okay. Our counterparts over in the borough have a similar issue that they're tackling right now, and I believe they have a special meeting this evening. And some of us may be interested in participating or at least be aware of what's going on at those meetings also. So I asked the Township Committee as it moves into 2020 to consider speaking with the Township Committee, whatever the governing body is in the borough, to not match their special meetings on the same night. Both of us are tackling the same problems, and specifically the big impact, I believe, is going to be the River Road development that they're thinking about. That's right down the road from us, maybe not so much in town, although we may be a little bit passionate about Post Office Plaza, but I think it is important that we be able to at least attend those meetings if we so desire. Thank you.
Thank you. Please.
The record will show that Mr. Ritter has arrived. Notes here. Thank you. Mark Hamilton, Highland Avenue. I just had a couple questions. One is a very specific point that a couple people asked me about, and I'm curious about as well, which is a committee member, Ness, published a report or whatever, you have it on Facebook or wherever this week or since the last meeting, specifically talking about the debate on affordable housing and the settlement, and included in that, and I'm reading here, the court is watching our meetings, reading news accounts, and taking comments very seriously. They reached out after the November meeting, asking if the township was walking away from the agreement after Karen made her statement. Now, I'm not sure exactly what that means, and with the understanding that there is litigation and the township is represented by counsel, I would assume that if in fact it is true that the court, does that mean the judge, somebody actually sua sponte or ex parte or whatever Latin terminology you want to read, was actually watching the meeting and on their own reached out to opine on what they were seeing at the meeting? Is that true?
Oh, you can address that.
I really am reluctant to comment on what is said or not said on Facebook. What occurred...
Well, let me rephrase.
But,
did the court reach out to you to comment on what it saw and its private observance of what's going on at these meetings?
And the response to that is I believe that there are certain conversations that are had that are really not public. But to the extent that those discussions were made public, I will address them.
Okay.
And that is, the next day after that meeting, the attorney for Fair Share Housing contacted me and I spoke with the attorney. That attorney also contacted our township planner, Frank Banish, and they spoke. And the special master reached out to the administrator, and the tone of it was, is the township moving away from the settlement? So there was, the judge, it would be, as you know, probably highly unlikely that the judge would contact an individual lawyer outside of the context of the other lawyers. You normally do that either in a in-court proceeding, or as we did this past Tuesday with a status conference or a telephone status conference when all the parties are present. But certainly, my adversary, Mr. Walsh, is free to contact me. The special master was appointed by the court and an arm of the court. Really, the special master serves as the advisor to the court on affordable housing matters, is interested in what is occurring. So that is the context that those contacts occurred. As I said, it was not the judge, but it was Mr. Walsh and the special master.
Okay, I just want to clarify that. Thank you. And it makes sense, frankly, that our adversaries and other people who are interested in this, would be following this. And I think it's been made pretty clear by everybody that nobody's advocating walking away from the settlement, and I'm sure you transmitted that today, and thanks for that. I did have a couple questions, or not today,
Well,
2 days ago.
Just to remind you that this committee, at the last meeting, when it adopted that resolution, asking for an extension, the last paragraph of the whereas clauses of that resolution reaffirm the terms and conditions of the settlement.
Agreed, yeah, absolutely. I was wondering if we could get a little bit more detail on the conference on the 17th. I read the judge's order that came out from the conference. It was a telephonic conference, if I understand, as opposed to court appearance.
Yes.
And it's not entirely surprising that, the court would, in my view, just my personal opinion, that the court wouldn't necessarily grant a significant change to the case management schedule or an extension on the fly on a telephone call like that. And I've seen it in publications as the request was denied. It sounds like it was more, he said, if I'm going to consider this, I need to really consider it through the proper channels with motion practice. And Mr. Cruz, please articulate your points in a little more detail as opposed to just saying them on a phone. And it said in the order that opposition was voiced by the other side. And I was wondering if you could give us some sort of flavor for the nature of that opposition, whether it was, whoa, Judge, this is the first time I'm hearing about this, I can't agree to this on the fly right now, can we get some more detail? Or was it, absolutely, hell no, I'll never agree to this over my dead body? Or if you could give us maybe just a little feeling for that conversation.
Well, in terms, as has been explained before, prior extensions were granted by telephone and a subsequent case management order without going through a formal process. The opposition was strenuous, and I would expect that when the township files files the extension request, we'll have the same opposition. However, again, I really don't want to speculate as to what Fair Share Housing may or may not do. The schedule has been set. The committee has given me direction on responding and directed me to respond, and I will respond with the necessary detail for the court to have, or hopefully present a record to the court that they can grant an extension.
Okay, great. Well, you anticipated my next two questions, pretty much, which were, it wasn't made totally clear to me that the briefing is ongoing. While we're going to be pursuing these other avenues that Mr. Kelly reported on, you're obviously going to be working on that formal motion for the extension in keeping with the deadline.
Correct. The judge ordered a briefing schedule and a hearing date, and I will comply with that schedule. But I also believe that the Township Committee, as Mr. Kelly has explained, should proceed with these options, because one of the things that I need to show the court is good faith.
Totally and completely agree, and I think that's a very wise course of action, and that would be included in the briefing. I'm sure that this sort of work was ongoing, and we were
Well-
looking at these various sites. But I'll leave that to your able skills. I'm
But
sure
but
it'll be fine.
remember, the motion is initiated on January 10th,
Understood.
which is before a lot of these things will occur.
Absolutely, I understand it completely, and I appreciate it. But and I think I got the gist. But I'll ask one more time. And again, I understand that you can't make predictions or anything, but it sounds like you're not optimistic that in between now and then, an agreement with Fair Share could be reached, for example, for some sort of consent motion or an agreement about a reasonable extension of the time, once you get a chance to provide a little more detail about what the committee is working on and the additional sites that are in play and the outside professionals that are being brought in to advise the committee and making it clear that it's not like we're just blowing it off, that we're working hard on this project. Do you think there's any possibility that that could occur?
Well, everything is possible.
Right, understood.
Okay, but I had the conference call on late Tuesday afternoon. This is the first time I've had an opportunity to speak with my client, the Township Committee. They've given me direction, and I don't know what's going to happen. We'll have to see what occurs between now and January 10th, and ultimately between now and February the 14th.
Okay, great. Do I got like one more minute, Greg? Okay. All right, a totally separate issue, which I know was addressed briefly earlier, which is the police station issue, which we talked about last week, Mr. Hoffman specifically, or last meeting, whenever that was, about some of the details of that, and I know there's some issues there. And I just wanted to sort of address an issue of the regulations in question. It's not my understanding that the township or the police department specifically has received notification from the Department of Corrections about certain non-compliant aspects of the facility. I guess the municipal detention center, I think, is the technical term. And it's true, obviously, there is a statute on this. It speaks largely to new construction, but I understand that the Department of Corrections has the authority to perform inspections and inform municipalities that their municipal detention facilities are non-compliant and effectively order or mandate that they be brought into compliance by a date certain. And it's my understanding that that is what occurred, correct? Yes. So I looked into it a little bit, and the statute requires,
You
Can I
can
just
finish your,
finish?
please. Finish your
Yeah,
thought.
the statute requires a very, very long list of things, including the Sally Port and various, you mentioned last time, the separate holding facilities for male and female detainees, and a very long list of things. And it's my understanding that this municipal detention center statute is applicable to all municipalities in the state of New Jersey, including Newark, Camden, Trenton, Irvington, places like that, as well as Chatham Township and Essex Fells and Harding and Glen Ridge. And the statute says that the corrections department can order any municipality to comply with these things. But it also says in the next chapter, in the next paragraph, the commissioner designee of the commissioner may exempt a municipal detention facility from adherence with a rule regarding minimum standards in instances where, one, the municipal detention facility is not in compliance with one or more of the requirements of the minimum standards, but two, the municipal detention facility is in compliance with the general intent and purpose of minimum standards, and three, the commissioner designee has determined that to require the facility to comply strictly with all requirements of the minimum standards would result in undue hardship. Now, in the context of the, thankfully, approximately 20 people or 30 people maybe per year who get arrested by the Chatham Township Police Department, largely for, motor vehicle and DUI type offenses, and, we could look further into how many times there have been multiple detainees in the jail at the same time, how many times there's been men and women in prison there at the same time, and what have you. And the fact that we received this a long time ago, and thankfully we still have way out into October 2021, what the status is of advising the committee and/or preparing an application seeking that sort of exemption from these requirements. Because as far as I could tell, like these communities I mentioned, neighboring communities, Harding, Essex Fells, Glen Ridge, small towns with minimal crime problems would experience undue hardship, spending millions and millions of dollars building these maximum security type facilities. And
Hamilton,
and
please,
it would be
wrap it up if you
undue.
can.
And so I'm just curious what the status of pursuing that exemption is.
Okay, thank you. Next person, please.
Is there a status?
Is there a status? Okay, go ahead.
Sure, the Department of Corrections was contacted by myself, and then I sent them a letter in October asking that an extension be granted to the township after 2021 so that we can come up with a longer-term plan. We have not heard back from the Department of Corrections, but, you know, the Assistant Commissioner was contacted, and then a follow-up letter was sent.
An extension of time, not an outright exemption from the requirement to comply.
That is-
has not been pursued yet?
That is correct. We wanted an extension of time, and then we also wanted time to put together a plan.
Next person, please.
Hi, Christina Mott, 22 Nicholson Drive. I just wanted to kind of ask Mr. Cruz much more basic questions about what you outlined about the timeline with the judge. So my understanding is that the judge said there was no to the extension immediately during your December 17th meeting, laid out the new timeline, where on January 10th, you're going to ask formally for the extension, and there's a few other dates that are over my head, and on February 14th, there's going to be a decision as to whether or not the extension will be granted or not. Is that correct?
A hearing.
A hearing.
A hearing, and judges in New Jersey typically come prepared to rule at the end of the hearing.
Okay, but not necessarily so.
Not necessarily,
Okay.
but I would think that in a matter of this type, that the judge will come prepared because, to rule,
Yes.
because he has received papers or submissions from the township, from anyone opposing it, and from the special master.
Yes.
And the special master will be making some sort of, either at a minimum, an analysis and perhaps a recommendation to guide the court. So if there isn't a decision on February 14th, it will be very shortly thereafter. I don't anticipate a long gap.
Okay, thank you. So then my next question is, I mean, I guess it sounds like you don't want to speculate what the judge might decide at that point. So I'll just skip to the next idea, which is, so if the extension is rejected on February 14th or about thereof, will it be necessary for you to then immediately name the site that will be used to meet this negotiated number? Or will there be some future date proposed that, you know, you'll then have a new date for making that I don't know, declaration?
I think that's hard to answer. I really would need to know what the opposition is, the nature of the opposition, and the opposition can also include cross motions. So the Fair Share Housing can also ask for its own relief. When you make these motions and you file these motions, I am asking for something on the township's behalf, but that doesn't mean my adversary cannot, on the other hand, ask for relief they deem appropriate. So it's...
Can you give an example of
Well,
that?
it's action and reaction.
Uh-huh.
So the answer is I would prefer not to speculate and wait until I have the response of Fair Share Housing.
So is it possible or probable that you will have to name a site soon after that February date if there is no extension granted?
I think from what Mr. Kelly explained is that the Township Committee is going to continue to move forward to identify a site or sites. We're not going to wait until February 14th.
No, but I'm asking, so I understand, like the committee is going to be working independently of this judicial process, right? So they'll be doing their analysis and you'll be working for the extension.
Correct.
But I guess I'm asking, when do those re-intersect?
Certainly re-intersect on February the 14th.
Okay.
Again,
I
you're
feel like I'm not
you're-
asking.
No, no, no. I
Asking
think-
in a way that you're
I think you're
understanding my
asking
question.
the question, and I'm not willing to answer it. Simply
Okay.
because I don't know, this is like a law school exam. You're asking me, if this happens, what will be the result? If that happens, what happens? I know what I have to do to get prepared for January 10th.
Okay.
The next step is waiting for the response from Fair Share Housing. While I'm preparing, I will anticipate or try to anticipate what their arguments are.
Okay.
But sitting here today, I don't want to engage in that speculation.
Okay. Thanks.
Thank you. Anyone else from the public?
Larry Feckner, 3 Rolling Hill Drive. I have a question about the Fairmount Avenue sidewalks. Just because I heard a resident from that area asking for an environmental study. In the past, when you do sidewalks, have you done environmental impact studies?
I don't think so.
We don't know.
Not that I know of.
Okay, I guess. The township engineer would know, or you think that's the right answer? We never do them.
The township engineer would know. I've been here since February 1st, but I'm not aware. The township engineer's in our zoning board meeting at the moment. So if you want to leave us your email address, I can email you an answer.
Okay, thank you.
Thank you. Is there anyone else from the public?
Ed Barmakian, Tappan Chatham. Albert, so if Fair Share Housing makes a cross motion, then you're going to make an answer to that, right?
Yes, the schedule that I provided, or that really the judge provided, is the township makes their motion by January 10th. Fair Share Housing responds by January 24th, and that it would be a response to the motion and any cross motions that Fair Share Housing desires to make.
Yeah, but if they make a cross motion, you'll have extra time to answer that, right?
I would respond by February 7th. It's not extra time, it's built into the schedule.
That's already built in. Okay,
Right, and
thank
the
you.
other 2 dates are February 12th is for the special master to submit his report, and February 14th at 1:30 for the hearing.
And the name of the judge?
Michael C. Gauss, Gaus.
Thank you.
Thank you. Yes.
Jerry Nigro, I live on River Road. First question I have is the foreclosure property, is that the property that is adjacent to the firehouse?
No.
No.
It's not adjacent to the fire.
No, it's on the opposite side of the road. It's contiguous to the upper portion of Cardinal Hill.
Okay, all right, because someone had called me and told me that the property on River Road adjacent to the firehouse was being looked at for affordable housing. Is that in fact true?
Next to the firehouse?
Yeah, we are in talks with the owner of that property.
Okay, I'm adjacent to his property. So my concern, besides the fact that it's next door to me, is the entire back of all that property on the river is protected wetlands. I'm thinking that the state DEP would have a very strong look at that. I can't imagine, since we have septic and no sewers, that they would allow affordable housing or any kind of large-scale housing put in next to the river. I would think that would tie up years of litigation with the state.
If I can?
Sure.
That's right.
Please.
Yeah. What we're looking at those parcels is we're looking to evaluate is if a septic system is feasible to be put there. That's the first step. So we're not looking at it.
Okay, well,
Right
that's
now.
all that is by the river is septic. Nobody has public sewers.
No, we were looking to see if it would be feasible because we understand that. We know that there's a significant wetlands constraint
Right.
on
I can't use
both
the back of my property.
on both vacant lots. So the question that we're looking at is, can can a septic system be placed on the property but outside of those the wetlands constraints? So that's what we're looking at right now.
Okay. I can't imagine the size of the property that you would have it. I'm next door, 2/3 of my property is wetlands, I can't do anything with it. Which is fine, it's gorgeous, I love it. Back to the river. But I can't imagine what portion of the property you would be able to build on and additionally put a septic system that would be big enough for an apartment building,
Well, we're not looking to put an apartment building there.
affordable housing.
Right, but we're not looking to put in we're looking to see if there's a septic system that could be put there. And then if a septic system could be put there, what size? And that would dictate the amount of bedrooms that would be available or the units that would be placed there, so.
Just to clarify that, no building will be on that side of River Road. If anything is put there, it would be a septic system. If,
Sorry, are you talking about right next to the Chatham Township Volunteer Firehouse?
On River Road, yes.
On River Road. So
Right.
There's two vacant lots. That's what you're speaking
The one that belongs to the firehouse. My understanding is part of that property belongs to the firehouse. And then there's a property that belonged to Arthur Paradise, which has been vacant for about 2 years. Foreclosed is my understanding.
No, there's not a property that's foreclosed. There's
well, it may
there's,
be foreclosed.
no, it's not,
Well,
there's.
no, there are two types of foreclosures.
I'm sorry.
The foreclosure that the township is talking about is a tax foreclosure. That property may be under a bank foreclosure, but, so it's two different types of
Of course,
foreclosures.
understood. Understood. Is it-
All right, ma'am,
Yeah.
there's two vacant lots next to the Chatham Township Volunteer Fire Department on River Road.
Oh, right.
One is owned by the Chatham Township Volunteer Fire Department. Another is not foreclosed, it's owned by another property owner.
Gotcha.
All right. Before we can even decide or approach anybody, about that, we have to do our due diligence and see if a septic field is feasible to be installed on those properties. If it's feasible, we don't own that property. The Chatham Township Volunteer Fire Department owns one of those pieces of property. They would need to give the township permission to use that or to sell that property to the township. So that's
Well, we're here to ask questions.
what's that?
We're here to ask questions to find that stuff
Yeah,
out.
so that's where we are right now. We're trying to determine if a septic field can be placed there.
Right.
Can it be placed outside of the wetlands constraints?
Right, so, but none of that property's been acquired for this purpose? No,
No,
but that was a question.
Okay,
Thank
great.
you.
Is it,
Thank you.
is it fair to ask, is it fair to say to what end we would be wanting to install the septic system, the septic field in that area? To what end would that be for?
Well, if we were able to put a septic field in, we would look at that to use that for affordable housing. But
So that would be with the intent to create some sort of structure on that
correct, but
property?
it wouldn't be an apartment house,
Not an apartment house?
correct.
On that side of River Road.
Right on that lot?
That's what my understanding was, and you said it was. I'm sorry. What you said was that there was no plan to build anything on that side of River Road. Is that what you said, correct?
I may have said.
But not an apartment house. I think that was.
What are we actually talking about when you talk about affordable housing? Are we talking about a house? No, we're talking about a multi-living unit.
That's correct, but we don't know if we could put one
Right,
there
no.
because we don't know if a septic field would fit there. There's something called the perk test that's been.
Right, no,
Yeah.
I understand that part. I understand that part, but my understanding in that conversation that we had, or the questions that I asked,
Yeah.
was that there was no planning to build on that side of the road. Now you're saying, if I understand correctly, if it passes, if you can get clearance to put septic there, you are going to build there. Is that what I just heard?
No, we're looking at that as that may be an option to build affordable housing, but the first step is to see if we can put a septic field there. If we can't, then that's something that's eliminated.
All
But
right.
we have an obligation to look at all of the.
Absolutely. absolutely.
Yeah.
But, you know, it's fact-finding for me.
Sure.
Sure.
Okay, next person, please.
Hi, Stacy Ewald, 54 Nicholson. I think there's a scheduling point that maybe isn't getting across, so I have a question for you. So at the last meeting, public meeting, people were told that we were going to seek a decision date of June 1st, June 15th, whatever, in June, a decision date that at that point, the analysis would be done about all the different sites, and then you'd come to the public and say, on June 10th, let's say, this is based on all our analysis what we want to do, and then go ahead with the cards. So that got rejected. So the question for the committee is that decision point accelerated now?
Al, you want to answer?
I'll speak for myself. I think we're going to go forward as reasonably fast, within reason as we can. We hope to gather information. We really honestly don't know how quickly we can gather the information we need to make the decision. We have to get numbers from a number of different engineers and architects and professional staff, and we are going to try to get that as promptly as possible. We know that we don't have until June to make that happen. We don't know, I don't know if we're going to have it in time for Albert to make a case on June 10th. I doubt it. January 10th. I doubt it. So somewhere between those two, we hope to pull our numbers together, and we'll be working with the courts, I'm sure, on that to try to keep them informed and move forward. You're asking a question about when we'll have all the data, and we don't know.
And I think court is looking for progress. I think as long as we make progress and show them the progress, I think they will work with us. That's what I'm thinking.
I just want to make sure that the public is, that we stay on top of, and I'll be up there to help make sure, but that we stay on top of keeping everybody informed as soon as possible, as early, and if that means an extra meeting in January or how, but to make sure we get that information out to the public as soon as possible, and they have reasonable time, given the constraints, to give their input. Thank you.
Okay. We agree.
Thank you. Anyone else on the phone?
Well, is there anyone new?
Is there anyone new?
that
Okay,
hasn't
none.
spoken before?
Okay. Second?
Okay.
Yes,
I've
please,
got
go ahead.
Mike Oyen, 3 Hillcrest Avenue again. I've gotten confused about a couple of things. One is that the intention of the January 10th deadline is to formulate a reason for the extension. And in doing that, we have to show that the former proposal that the court knows about is perhaps not the best proposal we can make, and that we want time to formulate a better proposal. We have to give them some evidence that that is possible, but you don't have to make any final decisions on the 10th. All it is buying us time to do a better job. Is that not correct?
The same question.
Again, you're asking speculation. I think there will be a formal request for an extension made. I have to look to see what kind of progress is made between now and then, what progress I anticipate will be made. Yes, there will be a request for an extension. How long remains to be determined.
Right, but we don't have to have our final site determination on the 10th.
The answer,
We could present a
As-
series of alternatives.
as a practical matter, I don't think it can happen before the 10th, okay? But I think we have to have a well-thought-out process of what's going to happen by when.
Right, which might involve the proposal for an examination of multiple multi-site developments, which I think was the thrust of why we need the extension. Is that, am I missing something?
Well, I go back, we're working within the confines of an existing settlement agreement. And so you're asking for renegotiation of a settlement agreement that was signed a year ago and approved by the court at the beginning of this year. So the Township Committee has to work within the confines of that agreement and present feasible alternatives or feasible plan as to how it's going to meet that settlement agreement. It's not an
Yes,
invitation
but
to renegotiate the agreement.
Right, but it seems to me that at best we'll be able to show that we have a process, but not the final.
And you're asking for speculation.
We can't keep going on the speculations.
Right.
We have to make a progress.
Okay.
And show it to the court, show it to the judge.
Sure.
And it's a negotiation.
No,
So
it's not a negotiation.
It's a negotiation.
Judge,
at some
I'm
point.
not going to be negotiating with the court. I'm
We're
going to
gonna
make my
make-
arguments to the court, and the court's going to make a ruling.
No, I understand, but you know what? We have to make progress, and we show that progress. It's real, and in my opinion,
Sure.
the judge will see that progress. And if that point we need more time, I'm sure we're in a better situation to get more time.
Right.
Not right now. So he needs to see the progress. I think that's what it is. And so that's what it is.
Okay. Second issue, I think I got a little confused on. It was my understanding that the River Road site that's to be developed for affordable housing is on the steep slope side, but that you're now talking about putting a sewer system on the river side of River Road. Is that correct?
No, we're going to be looking at a 5.69 acre site on River Road, which is on the Cardinal Hill side of River
Sure,
River
the
Road.
steep slope side. Yeah.
Steep slope side.
Right.
All right, and then the question becomes, if that can be developed, where can you put a septic system or
Exactly.
a package treatment plant? And that would be on the other side of River Road.
Right, which I think clarifies the issue. There was confusion.
And the confusion was because there
Yeah.
is a second location on River Road
Right.
that the township is doing some tests on. And that second location is next to the Chatham Township Volunteer Fire Department on River Road,
Right.
to the left of their driveway. So the question that I was answering had to do with that particular location,
Right.
okay?
Right. I think she was confused, though, as to the implication that the housing was going to be on the river. I was trying to get a clarification. I understand.
Thank you.
Okay.
Anyone else from the public who would like to speak? Yes, please.
Mark Lois, 15 Gates. Is this an appropriate time to ask questions about the development fee ordinance, or should that be later?
No, there will be a time for that, specifically for that ordinance, so it will be a little later.
Okay. Then I have one question about the
continue.
jail and the police department. Has it been explored at all, combining, much like the court has been combined with Madison, or there's been some arrangement made where we use the facilities there to use a jail that it maybe does meet the mandated specifications, maybe with the borough or another town? Has that been explored?
Go ahead.
Or do you want to answer it?
Sure, I had this conversation with the chief. Yes, it has been explored. The chiefs of a number of towns spoke about this. It didn't pan out. There was no town that willingly wanted to take detainees from other towns. It was a perception kind of a thing. It was part of a negative reaction, but the more practical reaction was that the sending police department would have to send one and very possibly two officers accompanying the detainee, and would have to stay at the receiving police department to watch that detainee. And that would change the staffing and the scheduling. And so not only was it a cost and staffing issue, but there was a perception issue that no town wanted to be perceived as the regional jailer for police departments around them. So it did not happen.
Then, I guess if that leaves us with, I guess, something more broadly, has it been more broadly looked at? I know that the borough and the township share recreation and education. Have you thought about the police department being another point where these communities would share resources? more broadly? Because then that would eliminate those concerns which you brought up.
I'm not aware of any specific study to merge the two police departments. As you say, there's been a lot of merging of services between the two towns and on a broader basis. I think that response times and things that come into play with police departments would complicate one police department that was serving a larger area. You'd have to have a satellite police department. I mean, it may very well have happened. I've only been on the Township Committee for 5 years. I'm not aware of any study during that time. Our administrator has been here less than 1 year, so I don't know if you have any paperwork about that having been done before our time.
No, there had been a study, or the police chiefs for, I believe it was 5 municipalities, had looked at the concept of creating a regional holding center. If one of the departments, if one of the facilities didn't work, but that was not cost effective as well. But no, there hasn't been in the recent past any studies about merging the two police departments.
Can I ask a question, follow up to you, Mike? When the chief spoke with the borough, was there a number involved, or was it a matter of like, could we do this? Or was it like, if we paid you $50,000 a year for this ability? Was there any kind of dollar mentioned, or is it just?
There was no dollar amount mentioned.
So we could go back to the borough. I mean, we know the borough's looking for money, right? So I mean, if we went to the borough and offered them a certain amount of money, they might have a change of heart.
There were two concerns. One was the perception, which was, in the opinion of our police chief, was a deal breaker. And then there was the concern from the sending town's part that there would be a significant cost and either a significant loss in police presence in town or an extra cost to staff up for it.
In terms of those costs, though, have we done the cost analysis compared to what it would be? This might cost $100,000 a year versus building a whole new police station for $3 million.
Not to my knowledge.
I don't think we've done that this year. I don't think it's been done in the past.
So it's something we probably should look into further. I mean, there's a possibility. In other words, you dangle a carrot in front of someone, the perception, the perception isn't necessarily you're taking criminals or whatever, from all surrounding municipalities. You're taking it from the township where you've already expressed, we have shared services in the school, the recreation, the library. So the perception is a little different, I think, when you're doing with the township versus, some other municipality.
I think we should look into merging both towns at some point in the future, honestly, not only police stations, in my opinion, again. Maybe. And how are we doing with the time?
I can restart once we get back to the living public talk.
No, I mean, are we done
We
with
still
the
have
5
time,
minutes?
right? I have about 3 minutes there.
Over 3 minutes if we can get back to living.
All right, would you please continue and?
Okay. Then I just have one other issue from selling a home recently in Chatham, and I still live here, and I've lived here for 10 years. The idea that we don't have parking or direct train, parking near the train is a problem. And it's becoming more of a problem for who anyone in this town would sell their home to. Because this younger generation wants more access, and I've seen it firsthand. The comments, I know Ms. Ness would know about that, and when I lived in Springfield, we had a jitney, and the jitney would take us from the pool parking lot to Milburn's, the station, and it wasn't something that I know Mr. Ritter has worked on it. It's something to do with this, but it's not something where there was just polling, and it was just something that was available, and I'm sure the town ate the cost of it for a bit until it picked up, and then people took it all the time. And there's several places I know that where people could park, but as a way of at least maintaining the value of everyone's home, we need to look at that as something. It's not a question of, we can improve the values here, or this is going to improve the quality of life. It's about maintaining the value that we have to solve that problem, because it's a problem that at least from what I see, the values in our town are flattish. They're not what they were. The town accelerated, growth and all the wonderful things that you associate with Chatham and especially the township are not what they were. So, is there any?
As it relates to the shuttle, as we had reported previously, there is overwhelming interest in this. The survey that we took, the second survey we had, was over about 140 people expressed an interest in using the service. Of the 72 parking spots, 36 in both the church and the Shunpike. The issue we found out later on from Transoption was that the state shuttle service did not want to be on the hook, as it were, for that 2-week pilot program, which, we would promote it. It would be, I think, $3.50, maybe $4, each way, so significantly less than the original $5 or $6 that we were thinking of originally. It's a matter of who wants to pony up, that $1,500, $2,000 in that 2-week trial period. We expressed before the committee didn't want to put money out there. That being said, maybe the next committee wants to pick up and say, you know what's $2,000 in the scheme of things for the trial period, see what we get out of it, because ultimately the intention here was the committee would not be on the hook for any of this. We basically would just introduce the idea, and then the state shuttle would take it off on their own. So ultimately, if you do the 2-week trial period, it's $4 each way. You would build up a kitty, as it were, a reserve, so that, maybe if it goes full-time and you have 50 people use the shuttle service one day versus the full 72, they could always take from the reserve. But ultimately, the question will be, it's the committee's decision to say, all right, let's pony up $2,000 or whatever as a part of the pilot and see what happens.
I think that sounds good. I have some marketing background, and I'll tell you, if I had a client come to me and say, hey, I'm going to do this for 2 weeks, what do you think? I would say, well, let's not start it then. 3 months, 6 months, 9 months, that would be an idea of a marketing plan, of an idea of something where you get people used to it. If you said, I'm going to open my gas station for 2 weeks and see if people come, it's not a great idea because there's not enough time to even build up any sort of branded reputation, nothing, right? So
I hear what you're saying. That being said, I think if you did a 2-week pilot program, I don't think you'd be...
It's better than nothing.
My point is, I think you would have maximum capacity on all those periods. I think you probably have more people complaining, I can't believe I showed up at 7 o'clock and I didn't even get a parking spot. I thought this would resolve our problems. It's
right.
Well, it did for 72 people, just not you.
So that would be great.
I would encourage the committee to think about it next year. You get the budget, pony up $2,000 or whatever for a trial period, and from there, to your point, see where you can go from there.
Okay. And then also, I know Madison is using this, what is it called, the Boxcar app. They're using that to sell spots and to take cash payments for a shuttle. At this point, I think it makes the barrier to entry too high. I mean, people are busy, and this is the last thing that they want. So there needs to be some form of digital payment.
I've spoken with Joe as well from Boxcar.
Wonderful.
And it's the same concern is, all right, ultimately, if you have, 70 spots and you get 60 people show up, who's going to pay for the difference in the shuttle that particular week if you don't have the reserve? And as I said, the position of the committee previously was, we've been down this road before when we did the jitney. It was a money loser thing. Apparently we purchased these jitneys in the prior years and wound up selling them because it was such a disaster. That being said, I've done some research where you go on these auction sites, the government auction sites in Hell, New Providence, and I think Berkeley Heights was selling a 14-passenger, school bus or other kind of shuttle bus for like $5,000. I mean, there's an analysis you can do where the township, you hired someone from, maybe the DPW workers could do it or someone else, you could actually make some money off of this. So it's not that we want to go out, but I mean, if you want to think about spending $10,000 or whatever the case, or $5,000 or whatever the number might be, all in costs from insurance and everything else, if it's even that much for insurance, given all the other vehicles that are insured, maybe that's something the township wants to consider in the future as well.
Thank you very much.
Thank you. Next person, please.
Hi, I'm Mike Mopsovich, 3 Sycamore Drive, and I'm late, probably on the same train as Mr. Ritter, so if this is redundant, I apologize. But Albert, you mentioned that you had made a proposal for an extension, and the court implemented this process to evaluate it. Was that the same proposal that the committee had made a motion to make last time, or was that modified?
Once the committee adopted that resolution, it was provided to the special master, the court special master, and to Fair Share Housing. And the only authority I had at the case management conference was what was stated in that resolution.
So to request that extension?
To request that extension,
Okay.
correct.
And then at this meeting, you said on the 10th, you will be making a motion to the
Correct.
court with some schedule.
Yes.
Will that motion be supporting the same schedule that was originally proposed, or a different schedule?
Probably a different schedule.
Okay. And when would we learn of the details of that additional schedule or a different schedule?
Part of what was outlined tonight was there's going to be, between now and the 10th, work done by various staff members, professionals. At that point, I'll have a better idea of what it should be.
Okay, so a new resolution of the committee would be needed for that different schedule?
That's a good question, and I had not thought about that. Typically, I am charged with preparing a response, and that's what I would do, is respond, or really not prepare a response, but make a proposal to the court of what the schedule should be. But I don't know if I'm going to have the ability to come back to the committee with that.
Okay, so who then makes that decision about what you will propose?
I think the same kind of analysis that was done before. I'll consult with the administrator, the other professionals, and try to come up with something reasonable. If I'm not able to consult with the entire township committee, I will certainly consult with the mayor.
So and I'm not familiar with the laws or the rules about decision-making here. Has there been authority previously delegated to you to make that decision?
Again, you're raising very good questions, and that I had not considered. What I was focusing on is the legal argument that I need to make to get the extension. Accompanying that would be a request for an extension. The mechanics of how I'll get that authority, I just haven't thought through.
Okay. Because I would think the legal arguments with respect to an extension would be directly related and dependent upon what extension you're asking for, right?
Well, part of the legal argument really is, has the township been proceeding in a good faith matter? That's the basis for the request. Showing the court all the things that have been done, showing what has to be done, and when it's going to get done.
Okay. And that would tie in with the types of things we discussed Saturday morning with Mr. Kelly. Having a process, what data we need, some idea of what sites we are evaluating. But I guess, there was a lot of discussion last time. The most vigorous discussion was around that schedule and whether or not people thought it provided enough time to do the background work and then get back in front of the community, get feedback, and then make it. So I'm just, I don't know if it would be well received outside of this room if people don't have a good answer for why the committee doesn't need to make another resolution to change that authorization they previously provided to you.
Albert, can I just try this? Because I think you didn't have the benefit of hearing the report that Mike gave and the comments that I made about developing within this schedule, understanding that this is a legal schedule going forward to try and continue to get the continuance. Separate and apart from that, the part of showing good faith on our part, as we would do normally, taking all the feedback that has been given, as well as our own feedback in looking at this, is that we're going to work on A, B, C, D options. Those options could be a multi-site option. It could be back to costing around what this site is, a combination of the skate park and this site, a combination of X site and Y site, possibly the River Road site. There's a bunch of things that we've gone back with and are looking at in terms of smaller developments and costing those out, and what we've said is what will come back to the public. In the interim time, because we have a meeting on the 2nd, and then we have a meeting on the 26th, and somewhere in between there, when we're able to get this information, because all of our hands are on deck, our planner, our engineer, everyone has already been reaching out since this last, well, since really October, in these multiple directions to come back to the public with these multiple options. Tell you what the costs are, what the implications are, and then get that feedback. If a multi-site option is going to cost this much more, and a 2-site option is going to cost this, or whatever it comes out to be, we don't know. But we want to get that feedback.
Before the 10th.
It can't happen before the 10th. So the 10th is so there's 2 separate processes going on. One is this process, and the dates and the times are outlined for Albert to go back at our direction for a continuance. In that same time period, we're going to continue on this path of looking at these multiple sites, coming back to the public, getting feedback, going back, trying to figure out what then is going to be the option. Then we'll hear whether we're going to get an extension. If we don't get an extension, then we're going to have to figure out what the next step is going to be. But we do have to provide direction to all of our professionals, including Albert, that this is what we want to do.
Okay. No, and it was pretty clear last time that when you had this call on Tuesday, we might get an answer we didn't like. And this isn't an answer we don't like necessarily. It's not a death knell. We have some more time, and we have an opportunity to make our case. But I guess, again, the only question I'm struggling with is, and I'm an attorney, and I get a lot of direction from my client, and I get a lot of autonomy from my client, right? Autonomy from my clients. They let me make some decisions. They don't let me make others. So here in this process, I'm just curious, you guys made a decision to ask for a specific amount of time on a very specific schedule, and now that might change. And I would expect, again, not understanding this relationship, that if I had a client and I was going to renegotiate a schedule or change it, purchase price in a document, something like that, I would need their consent. And that's really all I'm trying to get to the bottom of here. So if that's not answerable right now, hopefully we'll learn that answer at some point in the future. Thank you.
Is there anyone else?
Mark Hamilton, Highland Avenue, and I'll be brief, I promise. I think maybe, hopefully I can shed some light on this, and I was going to talk about what the gentleman before me just spoke about before, just hopefully clarify some things, maybe help Mr. Cruz clarify some things. But somebody said earlier that at the last meeting, the directive was given to Mr. Cruz to go to the court and ask for an extension, and that request was rejected, I think the word was used was, and therefore the time schedule had accelerated. And I think I understand, and please correct me if I'm wrong, that what happened was a large component of the community came out at the last meeting. There was a tremendous amount of debate on this, and ultimately the committee decided unanimously, I believe, to direct you to ask for a very specific extension. You went to the court and you asked for that extension, and the terminology that's being bandied about, that request was rejected, is not accurate. What happened was the judge declined to grant the requested extension based on this somewhat impromptu telephone conference, and directed the township instead to file formal motion papers supported by briefing and precedents and the various legal things, articulating the legal reasons why we were asking for that extension, and that we thought that extension was appropriate. And of course, Fair Share would have the opportunity to oppose that motion, and we would have the opportunity to reply. But it's my understanding that that's what happened. that the court said, Mr. Cruz, I can't grant that extension to you today. I need to know more, and I need you to formally move for that extension and explain in detail exactly why it's warranted. And so to that end, I wouldn't think that it's accurate to describe these as separate processes. There is the briefing schedule, during which I assume a large component of that brief would be the things that Mr. Kelly reported on. We have identified multiple sites. We need to bring in some people to do some studies. Even it's the Christmas holidays, and we haven't had a new committee meeting, and we need to keep the town informed about these various things. And I'm not saying how that would go over, but it was my understanding that this brief was going to support further in much greater detail the request that you had made this yesterday and that you were authorized to make at the last meeting. And I would agree with the other gentleman that some different schedule than the one the whole town came out to debate and was unanimously authorized by the committee would require another meeting, which I understand would be very difficult between now and January 10th. But is that an accurate understanding of the process?
Well, as I just indicated, I was focusing in on the arguments that I need, the legal arguments that I need to make to preserve the township's immunity past February the 14th, what it has done up to this point. It was certainly my intention to identify what it was going to do in the immediate future. But if you're suggesting that what I should propose to the court is the very same schedule that was in the resolution of December 12th, that would be something that the court, I do not believe, would consider. Okay? Because that is 10 months from now. That
I thought it was 6 months.
No. It brought the matter to a compliance hearing in September of 2020. And that is what all of this preparation is for, is to get to a compliance hearing where the township can show that it has met its constitutional obligation.
Okay, so that's a little bit more detail on the conference. So what we're hearing now is
Again,
that...
you're asking me to speculate. I agree that...
Well, did the judge say, Mr. Cruz, you're never getting 6 months? You got to come back and look for something less than that?
Well, a judge would not perhaps say that directly, but I think you can read in between the lines, okay? And if you've gone through enough of these conferences, you get a good sense of what the judge may or may not be willing to do. But again, it is hard for me to speculate here and, try to guess what the judge is going to do or what Fair Share Housing is going to do. The point was made, and I acknowledged it, that I should give consideration as to how I am going to be authorized to make a schedule proposal to the court. And I acknowledge that.
Okay, I appreciate that clarification, and I would agree with the previous speaker that, I have concerns about how that authority would be transmitted, but I'll leave that to the committee, but I do think that some sort of authority would be warranted. Can I just ask a really quick clerical question, Greg? Is the item on the agenda tonight about the development fee, is that scheduled for like a final vote to be adopted into law tonight, or is this more discussion on the issue?
Yes, assuming we get past the hearing of citizens, then yes, it is on for public hearing and adoption.
Okay.
I'm assuming that the committee votes in favor of it.
Okay.
Very good.
Would have been nice if everybody had known about that, too.
No, it is listed.
It is listed as the final
as
adoption.
public hearing and adoption.
And that was made clear at the last
Okay.
meeting?
Public hearing, final adoption of ordinance. It's right on the agenda.
Okay, so is there anyone else from the public? Seeing no one, and I am going to close the floor for the public hearing for this section. So I'm moving forward with the agenda item of the final adoption of ordinances. Number one is ordinance 2019-19, Fairmont Commons Overlay Zone, a resolution 2019-229, reasons resolution. Greg, do me a favor, you can read the heading of the resolution. I don't want to torture anybody.
ordinance of the Township of Chatham, County of Morris, State of New Jersey, establishing an inclusionary affordable housing overlay zone in the PI-1 Professional Institutional District and amending Chapter 30, titled Land Development, Article 7, titled Zoning Regulations, applicable to Block 128, Lot 9, located at 466 Southern Boulevard, to address a portion of the Township of Chatham's third round affordable housing obligations.
Okay, great. Thank you, Greg. And before I open to the public, you want to just give us a quick feedback?
Yes, Mr. Mayor. Because both of these are zoning ordinances that were referred to the planning board for a master plan and consistency review. On December 16, 2019, the planning board reviewed both the Fairmont Commons overlay zone ordinance and the development fees ordinances. In each case, the planning board found that the ordinances were inconsistent with the master plan. However, in each instance, the planning board recommended that the township adopt the ordinances. The township planner submitted reports dated December 16, 2019 to the clerk regarding the planning board's review and recommendations. The clerk circulated that report to the township committee. So the township committee does have jurisdiction tonight to continue the public hearing and vote on this ordinance. If the township committee is inclined to adopt each ordinance because the planning board found that the ordinances were inconsistent, the committee should first, before voting on the ordinance, consider a reasons resolution, and these are separate resolutions for each ordinance before proceeding to vote on each ordinance. A reasons resolution states, as it says, the reason or reasons for the township action in light of the inconsistency determination by the planning board and must be received for 3 affirmative votes. With that explanation, Mayor, I will also add a second explanation. The Fairmont Commons ordinance is an overlay over a specific piece of property that simply sits there as an additional opportunity for that property owner now or in the future to develop that property for residential use and up to, I believe, 12 units per acre with a set aside of either 15 or 20% depending upon whether it is rental or market. 15% if it's rental units and 15% if it's rental units, 20% if it's for sale units.
Okay, great. Yes, Bob.
I just wanted to let the committee know that at 4:50 this afternoon, I spoke with the owner of Fairmont Commons, and the owner, just wanted to let me know that this overlay is creating an option for them in the future, but their plan is to keep the property operating as it is now successfully as a commercial property. It's been successful as a commercial office space since 1986, and that is their intent to keep that going into the future. And they have no plans to make any changes to it. They have worked very hard to renovate some of the buildings and to make sure that their office space is close to being fully rented, and that's their intent going forward.
Thank you. Mike, you want to say?
2 items of explanation, Mayor. There was a suggestion a moment ago that our publication on this ordinance and the next ordinance was inadequate. And I just want to emphasize for the public and for the record that at our last public meeting, we opened a public hearing on both these ordinances, and we clearly announced that the public hearing would continue to be open until tonight, and at which point we would have more public comment if anyone wanted to, and then we would consider a vote. And the reason for that was that we had to allow time for the planning board to do its master plan review. And that's the second item of clarification, is that there is in both these ordinances a reasons resolution which comes into play when a planning board finds that an ordinance is not consistent with a master plan. But in both these cases, our planning board specifically went further than that and they recommended the adoption of both these ordinances because while they were not technically inconsistent with the wording of our master plan, they do advance the goals and objectives of our master plan. So we are moving forward with the full endorsement and recommendation of our planning board in both these cases.
Thank you, Deputy Mayor.
If I may add to Deputy Mayor Kelly's statement, in addition to the announcement at the last meeting, an agenda was posted on the township website last week on Friday that indicated that this matter would be considered tonight.
Okay, now I'm opening this to the public for discussion specifically for this ordinance. If you have any comments, please come to the microphone and speak. Yes, that's only for that. Yes.
Richard Matlaga, 36 Dale Drive. Will there be committee discussion on?
It will be.
After the public?
Yes.
Simple question, and it gets back to the affordable housing settlement. Here we go, these are all connected. So this is an overlay zoning, and my concern is that the township cannot meet its 74 units. So if it cannot, and this is an overlay zone, whether it's this overlay zone or any other property, can the court, the settlement person, tell the township to use eminent domain to take property such as in an overlay zone or any other property to be used for affordable housing?
Okay. Al, would you like to answer that?
The law at this stage is no.
I mean, it's not done until it's done, or is it no?
No, the law does not authorize condemnation for an overlay zone.
Or for affordable housing?
This goes to meet an unmet need. Okay, this does not go to the 98 units that have been discussed. There is an obligation for an unmet need. What you need to do there is plan for it, and that's what this is. It's a plan to meet the unmet need, and it meets a portion of that, and that is sufficient for the purposes of satisfying the affordable housing obligation.
Okay. I'm not,
Okay.
I don't have a follow-up.
Anyone else? Okay. Now I see no one, and closing the floor for public discussion. And do I have a motion to adopt?
No, the first motion would be a motion to adopt the reasons resolution.
Yes. Do I have a motion to adopt the reasons resolution?
So moved.
Second.
Any committee discussion? Okay, roll call vote, please.
Mrs. Ness?
Yes.
Mrs. Schwartz?
Yes.
Mr. Ritter?
Yes.
Deputy Mayor Kelly?
Yes.
Mayor Salin?
Yes.
Motion passes.
Okay, great. So we're moving to the
Development fee ordinance.
Okay.
You're opening.
Ordinance 2019-22, development fee ordinance. A, resolution 2019-230, reasons resolution. Greg, would you like to please read the heading of the resolution?
Resolution of the Township Committee of the Township of Chatham and the County of Morris outlining the reasons for enacting ordinance 2019-22, an ordinance of the Township of Chatham, County of Morris, New Jersey, amending Chapter 29 titled Affordable Housing of the Revised General Ordinances to add a new subsection 29-2 titled Development Fees.
Okay, great, thank you. And Al, would you like to give any feedback, or should I just open it up?
This
You already
ordinance,
have,
this
but-
ordinance has been under discussion, I believe, since October.
Yep.
So if you have a specific question, I'm happy to answer it, but
Okay.
I think the committee and the public is familiar with it.
All right, I'm opening this ordinance to the public discussion.
Hi. I'm Ashley Felice at 20 Candace. I would like to express my opposition to this ordinance. This development fee, as you call it, is nothing more than a penalty tax for someone who's trying to improve the value of their property. When an individual is investing money into their home, they're adding value to their property. Value added to their property in turn adds value to their neighbors in the form of a higher price comparable property. This on a large scale adds value to the neighborhood and likewise the town. This is something we should be encouraging as it positively impacts every single property owner in the town. This should never be discouraged or taxed in any way. Additionally, when an older home is purchased by a developer who wants to build a multi-million-dollar home on that site, the township will be collecting more money in property taxes every year. A $500,000 home pays approximately $8,500 a year in property taxes, as opposed to a $2 million home, which will be paying approximately $33,500 a year in property taxes in perpetuity, a $25,000 increase to the town every single year. Also, while you're selling this as a tax to the developer, you're most likely just taking it from the pocket of the selling homeowner. The developer will not just take the tax hit. They are too smart for that. They will pass it on to the current property owner. For example, if a developer came knocking on the door of an older home, which they've been doing in our town for years now, offering to pay the owner a cash value for their property, I can guarantee you that cash value will now be less to the current homeowner by the exact amount of the tax you are charging. Ultimately, the developer can go to another town where this tax is not in place or pay our citizens less for their asset. If your ultimate goal is to raise money to fund affordable housing in Chatham, this is the wrong answer. This will only discourage growth and development in Chatham. Additionally, putting this money into a trust fund that is controlled by the same state government that has abandoned us in this entire affordable housing situation, is absolutely nonsensical. Our town is tiny. We're not Morristown or Newark or Jersey City. We're 3 miles wide with 11,000 people. We simply don't have the infrastructure to support these affordable housing numbers that they're requesting. Our roads, schools, police, etc. simply can't sustain the added numbers that they've requested to be added to our town. If the Fair Share Housing Commission gets what they want, our entire small town way of life will be changed. The roads will be overcrowded, the trains will be packed, our already overcrowded schools will no longer have the prestigious rankings that they have, our property values will have dropped, all resulting in less taxes for the township. It's time we stand up for the town and fight back, not hand them a trust fund to the very people currently suing us.
Okay, thank you. Just one correction, that's not going to be managed by the state, so that's town. Just so
That's
you
what it says. We're in the order. I looked it up in the ordinance. It says that it has the ability under the use of funds part.
Okay.
It says it is. I mean, if that's wrong, please correct me. But it does say that.
I'll
address that, yes.
Okay, he will explain.
So
Thank you. You want to explain?
You said a couple of things. One, that adjoining towns do not have development fee ordinance.
I didn't actually say that. I said there are other towns out there that don't have it. I didn't say anything about it.
Do you know any town that doesn't have it?
I mean, I can look it up.
The vast majority of towns have a development fee ordinance. It's the rare exception of the town that doesn't have a development fee ordinance. The trust fund is maintained locally, and disbursements from it are based upon a spending plan that's adopted by the Township Committee and will ultimately be approved by the court if we get that far. And so it is, what you're looking at is it provides that the trust fund is a tripartite agreement, but it is a trust fund maintained by the town and controlled by the town, and expenditures are made consistent with a plan that's authorized by the town.
But it's still monitored and it's still this, by the state. They can still come in and grab it.
It can be, it is monitored, yes,
Well, that's
monitored. And under the law, the state, the current state of the law is that the municipality has 4 years within which to spend the money that it receives. So it's intended to be a circulating fund. So it is locally controlled, locally kept. The chief
It's still
finan-
monitored by the state, is my point.
And that is a very good thing, because the municipality should meet its obligation through the spending plan. So yes, it's good that somebody's monitoring it. And it's good that it's an outside party that's monitoring
I
it.
just am expressing my opposition to, I grossly
That's fair.
disagree.
That's fair. Okay.
That's all.
Okay, thank you. Anyone else?
Mr. Clerk, did you take a vote on the resolution only, or did you also take a vote on the ordinance?
It was only the, we still have yet to have a motion
Okay,
and a
so-
second for the overlay ordinance.
Okay, so it's a two-step process, and I apologize, the committee started with this, but you need to adopt a reasons resolution and then vote on the ordinance. So you have either one of two choices. You can do that now, or you can wait until this part of the public session is, and then you will go back and vote on that Fairmont Amos. What would you suggest, Mr. Clerk?
I would suggest we settle one matter before moving on. I think we should take care of the overlay ordinance and then move back into the development fee.
Why don't you have that done now, and this way we won't forget.
Now, okay, so the ordinance 2019-19 Fairmont Common Overlay Zone, this is the ordinance, not the reasoning resolution. So now
Need
do I
a
have?
motion and a second, and then committee discussion?
Yeah, that's what I'm going to do. Do I have a motion to
So
adopt?
moved.
So, second.
Okay. Any committee discussion? Roll call vote, please.
Mrs. Ness?
Yes.
Mrs. Schwartz?
Yes.
Mr. Ritter? Yes. Deputy Mayor Kelly?
Yes.
Mayor Selin?
Yes.
Motion passes.
Thank you.
Now, going back to the
All right,
development fee
we're going
ordinance.
back to Mr. Metlaga. I'm sorry about that, please. Introduce yourself.
Richard Matlaga, 36 Dale Drive. To follow up on towns that don't have the development fee ordinance, what I heard at the planning committee meeting, and correct me if I'm wrong, that the township had passed the development fee ordinance. It was activated, and this are the terms they use, it was activated and then rescinded. So it wasn't in effect. So then you question that it's coming up now. And from the taxpayer point of view, this sounds like death by 1,000 paper cuts. You're going to put more fees in than we can handle. So you've been paying whatever was required, but how much is required? How much do you have to raise for this affordable housing? And is this development fee, is that where you expect to get 100% of what you need to raise? Or is that where you expect to get 10% of what you need to raise?
Yes, please.
Mr. Matlaga, the introduction of it in the historic past, my understanding is that it's a two-part exercise. There's a development fee, but you also have to have a spending plan that the courts also approve. And back at the time that the development fee was adopted, there was no number of units that the township was obligated to provide. Therefore, there was no spending plan, and therefore it couldn't complete that exercise. So the development fee never was put into effect. Now, in terms of your second question, we don't have the answer to either side of that formula. And I think the planning board tried to explain that the other night, but for the audience here tonight, let me try again. We earlier tonight explained that we narrowed our choices down to 6 particular sites, and we are directing our professionals to go forward with all deliberate speed to gather the costs and the other impacts of developing affordable housing on all those 6 sites. we don't have the expense side of the equation that you're asking for. So that's half of the problem. The other half of the problem is that we don't have the revenue side of the equation that you're asking for. We've done some projections of what a development fee might produce based on past history. If the same number of houses are built, if the same number of knockdown and rebuilds happen, and if the same number of large renovations that either are a 50% increase on the assessed value of the house or increase its size by 2,500 feet, because that's the square feet, because that's the threshold where this fee kicks in. So we do have some projections based on historical facts, but there's no guarantee going forward whether those exact numbers are going to continue to play out. So we don't have either side of the equation, revenue or expense, to a fine-tuned number. Our guesstimate is that it probably would not cover all the expenses, because while we know some of the expenses, like our contribution to Vernon Grove for the extending of their affordability controls, we can project the costs of our professional staff, but we have not yet gotten the results of some of these sites where developers have to go to the state, apply for tax credits, which could be at 2 different levels. They could, or nothing, they could fail entirely. So all those variables have to be answered before we know what the township's contribution will be to those projects. So there's a lot of questions that need to be answered between now and then.
And it's just places it on the taxpayer of saying, I'm putting in a fee, I don't know how much I need to raise, it may be inadequate, and I may be coming back to the taxpayers anyway, and it's for affordable housing, which is in essence a community kind of, you know, I just look at this saying this is a punitive tax, and it is a tax. I don't see how you could vote for it.
But in saying that, you're saying that what we should vote for is to put it on the general taxation.
Yes,
I think
because
in your mind, it's fair.
you are making a commitment for this affordable housing for all. You have entered into a settlement agreement on this affordable housing so that the owners of Dixie-Dale got their money out of their land. I live on Dale Drive, which is a tear-down neighborhood. I live in a Kaplan house that was built in the mid-50s. As a matter of fact, I'm the only one in town with a bomb shelter in their house.
I know of one other, I have to tell you.
So,
in Rolling Hill.
So I look at this saying that I will be burdened with this tax, and it's a tax, of 1.5% or 2.5%. And my next question is, how do you define a non-residential developer and a residential developer? But I am going to be hit with this tax. So as I go through that, Dixie-Dale didn't have to pay it. Rosevale, who sold that property, didn't have to pay it. The Hiles didn't have to pay it. Now all of a sudden, let's beat up the people that are in town because I entered into a settlement agreement that has so many unknowns, it's unbelievable. And I've never entered into a business contract with that many unknowns. And then, as I said, this is death by 1,000 paper cuts. You are just nickel and dime me here, here. Put it on the taxpayers. You committed to it. You're selling it as this is good for the town. Your sales pitch is Dixie-Dale is good for the town. Then everyone pays their fair share and not to just one. That said, my other question is, what is the definition between a residential versus non-resident? What do they call them? A residential development and a non-residential development. What's the difference?
One is residential, one is commercial.
Non-residential is commercial. It's not that if I sell my house to Joe DiMarzo, who's from Madison, he's a non-resident.
You look at the use.
No.
No, if it's a retail establishment or anything, it's any commercial.
It's a it's
Yeah.
residential versus commercial.
You may
Okay.
sell it to a commercial developer, but the use is residential.
So it's residential.
It's residential, yes.
Okay. Thank you.
Thank you, Mr. Metlaga. Okay, anyone else from the public? No, I see no one, and I close it to public. Oh, I'm sorry, go ahead. Come.
Thanks for the opportunity to talk. My name is Mark Lois. I live at 15 Gates in Chatham Township. It seems to me basic financial management, you try to match outlays with revenues. And this fails to do that, this fee, because it's a one-time fee, and it's meant to recoup some building costs. But those are known, defined, one-time costs. The real cost and burden is the expansion of services that are needed for these all of this affordable housing. And what you're doing actually is you're going to limit the amount of development that's going to go forward and stop the serendipitous, wonderful cycle of these teardowns and expansions of homes that have caused an expanding tax base. And I heard it said that Chatham Township is unique and that we don't have this fee. But we are unique, we are exceptional, and we are better than a lot of other places you can live. And since I live here, I'll say we're better than everybody else. It's a wonderful place to live. And a lot of it is funded by that serendipitous cycle. And I don't know why we'd put anything in front of us to impede that. And I don't know why we would put anything in front of a developer to give us additional revenues in the future for the homes that, quite frankly, if you're paying $33,000 in tax and you bought a $2 million home, you use very few services from the town. That's the best possible resident, future resident that you could attract for future residents and for the current residents. So it doesn't seem to me to be a responsible thing to do for the future to adopt this ordinance.
Okay.
That's what I wanted to say.
Thank you.
Thank you.
Anyone else from the public? Okay, I see no one, and I close the...
Mr. Mayor, if I could just make a comment?
I closed it. The public, I closed this public session. Yes, you can make a comment.
Sure. The question about the development fees, there's good discussions on both sides of the coin, but I'd like to point out that while the township is evaluating the development fees, we have a 2% cap, and so our expenses can rise 2% per year, and if we have the development fee will help offset the pressure on our 2% cap. And that's important to know, because as we try and be diligent with our services and the cost for our services, we need to make sure that that our expenses don't exceed our 2% cap.
Okay, great, thank you. And now we're doing the ordinance first. Resolution first. Okay. Do I have a motion to approve the resolution?
Why don't you read it, Greg?
Okay, reading for the second time. Resolution of the Township Committee of the Township of Chatham and the County of Morris outlining the reasons for enacting ordinance 2019-22, ordinance of the Township of Chatham, County of Morris, State of New Jersey, amending Chapter 29 titled Affordable Housing of the Revised General Ordinances to add a new subsection 29-2 titled Development Fees.
Okay, great. Do I have a motion to pass the resolution, approve the resolution?
This is the reasons resolution?
This is the reasons resolution.
So moved.
Second.
Any committee discussion for the reasons resolution?
I don't mind chiming in right now to say that I will be voting against this reasons resolution, having sat on the planning board for a number of years now and attempting with some of the finest volunteer minds that I know in this community who have the best interests of our natural resources and our housing resources and our circulation resources, et cetera. I find that there is no substantial reason to override the master plan when it comes to the imposition of a developer's fee on improvements to a home. And we had an abundant discussion on the size of a 2,500 square foot addition and how it's massive and how homes don't, anybody over 2,500 square feet is going to know they're rebuilding their home essentially, regardless of the hue and cry of how big a 2,500 square foot addition may be. I do believe that it is a penalty on somebody who seeks to improve upon their home, and I believe that imposing a developer's fee on that addition is wrong, and I believe it is inconsistent with the master plan, and the reasons resolution is not something that I'll approve of.
Okay. Anyone else from the committee? No? Okay, roll call vote, please.
Mrs. Ness?
Yes.
Mrs. Schwartz?
No.
Mr. Ritter?
No.
Deputy Mayor Kelly?
Yes.
Mayor Slin?
Yes.
Motion passes.
Thank you. All right, now we're going to
We
do
still
the
have to-
ordinance
Yeah.
this time. Okay, I don't do public, we've done already, right? So for both, okay. So.
Can I just
do have
ask a
motion?
question?
Yes.
Albert, in terms of the agreement, the developer's fee and a bonding ordinance and a spending plan was all part of the agreement?
A bonding ordinance?
The developer's fee and a bonding ordinance is a part of the spending plan that is supposed to, or a bonding plan, or mechanisms to fund affordable housing that were agreed to in the settlement.
Yes, embedded within the settlement, there is you have to have a trust fund. So it was part of the settlement. Bonding was not included in the settlement agreement.
So it's just the trust fund.
But a spending plan was, and the spending plan has been developed. It hasn't been finalized because of the debate that was discussed a moment ago of the size of the addition, what would trigger that. So that is something that will come before the Township Committee in January, a spending plan. It's been worked on by the planner, by Mr. Hoffman. It's been looked at, I believe, also by the CFO. So there have been various steps to look at that plan. It isn't here tonight because of the uncertainty. Okay? There will be a requirement that, because again, the option of 100% municipally sponsored site, of having a resolution of intent to bond, would also be before you at a future date, probably at the next meeting also, when you have the spending plan before you. But yes, those were all embedded within the settlement agreement.
So, just to be clear, the development fee ordinance was something that the committee settled for as part of that agreement?
It was part of the agreement, yes.
Thank you.
And the amount of those fees were determined in that settlement agreement, or no? Or that's being determined in this ordinance tonight?
It's statutory. It's 1.5%. Under the municipal land use law, there is a provision regarding development fees, and it's 1.5% for residential, 2.5% for non-residential.
And in that settlement, did it specifically apply to improvements, or was it for developer fees and primarily for tear downs?
The regulations regarding the development fee ordinance provide various mechanisms and various options. You chose, and I don't mean you, I mean the collective committee.
The three folks to my left.
Okay.
Karen's left.
The committee.
You voted yes to.
You voted yes too.
I didn't say yes to the fees for.
We're not talking about this.
That's what I'm talking about.
What your
That's
question was.
That's my question to Albert was, is in the settlement agreement, did it include fees for people who are doing renovations to their homes?
That specific was not. That
Thank
is
you.
left up to the.
That was my point.
To the
Yeah, no,
Township Committee.
you actually amended this ordinance. And
to
voted.
take it out, originally. Then we amended it.
You
You
amend-
amended it. We voted no against it. Look at the records. Don't tell me I know what I did, all right? Karen and I were in total agreement that this is a tax on our residents,
Okay.
right? And
So
it's a
let me go
tax,
back
if you
to
guys
this.
want to raise taxes on our residents, you three can live with that.
My actually.
Run on that campaign next time.
Here's how I think, and we shouldn't raise taxes.
You're doing it, Typhoon.
We
You're doing
shouldn't
it.
do it
You're
to
doing it.
everyone. If you're
You want to
already.
raise taxes on great, soundbite,
Let me
love
finish,
it.
let me finish. I am not raising taxes to everyone. This applies to the developments that happens in this town that is larger than 2,500 square foot and tear downs and new constructions. So that is not the majority of the town. It is a small portion of the town. We have 4,200 homes in this town.
Yes?
This will probably apply to 40, maybe less homes, projects per year. I rather do that than increasing taxes for 4,200 people,
Good.
4,200 homes.
And I interpret that as you saying, I'm in favor of raising taxes.
No.
That's what you just said.
That's exactly what I
Can
not
I-
said.
You did.
That's
I just
exactly what I
wanna-
didn't say.
That's
I
exactly
want
what you
to
said.
I want to get away
If it's
from
40
the.
people or 4,000 people, you said, I'm in favor of raising taxes.
I am not in favor
Then
of
vote no against
raising
this ordinance.
taxes.
Then
I
vote no.
am not in favor of it.
Then
All
vote
right,
no.
can
Okay.
I get away from trying to get the political soundbite and
There's
actually
no political
do
soundbite here,
what
Tracy. It's facts are facts.
you just said? Great, soundbite.
Yeah,
So-
that was his soundbite.
All right.
Yeah, well, that's
Yeah.
what you're looking
All right.
for. So
For
let me
what?
just
I'm
get
not
away
looking
from
for- I don't
that.
need
And
sound
I
bites.
want to talk about what the implications are for the township. So this developer fee was passed by this committee as part of the settlement. We are now attempting to get a continuance. Part of showing good faith in this is not walking away from the settlement, not deviating from what you agreed to and negotiated for 3 years. So I'm going to vote yes for two reasons. One, we have no money. There is $0 in the Affordable Housing Fund. We are facing an enormous amount of costs. And number two, I'm not looking for a political soundbite. I'm looking to do the best that we can with the judge to enforce the settlement that happened in 2018 and give us the best chance to get our fourth continuance so that we can continue to work on this. By voting no against something that you voted for a year ago,
Not true.
and that you know that is going to be viewed by the court as not advancing these efforts that the township is trying to do to get to a solution for our affordable housing, I can't understand that at all.
I'm happy to explain it if you'd like me to.
Go ahead, because
Yeah.
it's very difficult to
If
understand.
you recall, back in October when we argued this ordinance, right, Karen and I were adamant against adding fees to people who do renovations to their homes. You all three were in favor of it.
We-
You shut down.
We carved it
Past
out
October.
so that it would be 2,500 square feet and above. We had all the numbers, we had all the analysis, and we went
Karen
through
and I
this.
said we didn't want any tax on residents who are doing renovations to their home.
You're targeting a certain subset of our residents who are trying to improve upon their homes. You're targeting them. You're pulling them out of the general tax base and saying you are paying the
Well, what
penalty.
did you think you were voting for in the
I
settlement?
voted against it. In the settlement, this is a town-wide thing, as our residents have already said. This obligation, and we five are right now obligated to fulfill the settlement agreement that we have stated more than once that we support, correct? We five represent 10,000 people, I believe, in this town. We represent the taxpayers in this town, and we are carving out this subset of people who are going to put a really nice, strong addition on their house. I live in a house that's less than 2,500 feet, but I'll tell you what, if somebody comes in to buy it, they're going to put an addition on that's 2,500 square feet. Believe me, and the person who's gonna come in and buy my house is going to all of a sudden be hit with this penalty, singled out, carved out of the general tax base
So what was
and paying this penalty.
what was your understanding then in the settlement
It's
when
not-
it required?
My understanding is, number
the-
one, I voted against the
No,
2,500
let me
square
ask the
foot ruling
question. What
on a
was your
number of occasions.
understanding when you voted for the settlement that said development fee?
Tear downs alone, not renovations. And that's the art, we go, look at the videotape,
That
as
was
Warner Wolf
always
would
the
say,
case.
right? This is what we
No,
argued
she's asking,
about.
I think she's
The
asking.
settlement
This is what we
agreement
argued
in and of
about-
itself,
I
the
just-
settlement
This is
And
what
we
we argued
defined-
about this past October,
And
about
we
this
defined,
ordinance.
and we defined tear downs as 25, we looked at all the figures, Bob did a whole analysis.
We did
No,
not
no.
define tear downs as 2,500 square foot improvements.
How would you like to define tear downs?
Taking down a house. Goodbye.
There are three categories. Additions in excess of $2,500.
Yes.
Tear downs, and
And total
totally new
rebuilds.
constructions.
That's on virgin land, as Bob calls it.
Which is
Which-
really,
Where are you gonna find virgin land?
Yeah.
Regardless of that.
Yeah.
Regardless of that, if you're asking about how we expected to fund this entire settlement agreement, if we said we were going to set up a spending plan as a component of the settlement agreement, that's one thing. But to carve out 2,500 square foot additions in some developer's fee ordinance, which has been proven to be inconsistent with our master plan, you're not going to lay that one on me, because I'll tell you what, I did not vote to carve out a 2,500 square foot addition. We might have talked about a spending plan. We might have talked about a trust fund, but we did not, and I sure as heck did not, say that we were going to lay this on the feet of people doing a handsome addition to their house. That's you guys.
Yep.
Okay.
And
Okay.
I'm going to vote for this development fee because a vote against it is, without equivocation, is a vote to spread that cost over every taxpayer in town. And that includes every taxpayer who is least able to pay for a tax increase of any kind. So that you are saying that while you don't want to vote for a development fee, you are in effect voting for a tax increase on everyone in town. That's the choice, because there are expenses that have to be met. They're going to be met one way or the other. And I think that a development fee that is passed in advance, it's not retroactive, so that any development, they know in advance that there's going to be a fee attached to it. And it's a 1.5% fee. And I think that the development fee puts this extra cost on the people who are most able to pay. They are financing an addition to their house that is bigger than most homes, 2,500 square feet. They are knocking down or totally replacing their house, and they're building a brand new house. And we are placing this extra 1.5% on those people who are making that decision to spend hundreds of thousands of dollars, rather than put an extra tax on, take your pick, on the least able to pay person in town. And that is unconscionable. And I am going to proudly vote in favor of a development fee.
It's a different approach. I think you don't want to raise taxes, I don't want to raise taxes, but we have to pay for the bill. We have to pay the bill. And there's a bill. Let's figure $100,000 or $200,000. How are we going to pay the bill? You're saying everybody needs to pay, and I'm saying no. The people who are improving their homes more than 2,500 square foot, which is a substantial. So, or new development or tear downs. So that's really, it's different approaches. And I think we both don't want to raise taxes, but there's only one constant. The bill is out there to be paid. We have to pay it. And you want to pay it differently, I want to pay it differently. So that's all it is, in my opinion.
Just to clarify one other statement that was made earlier, the planning board voted 8-1 to say that while it was inconsistent with the specific language of our master plan, which was adopted, they went back to our 2005 master plan in order to clarify the language. while it was inconsistent with that nearly 15-year-old language, it was totally consistent, and it advanced the goals of the master plan, and they recommended that we adopt it. So just to clarify that position as well.
Okay, so if there's no other discussion, is there anything else from anyone? So because I'm gonna go to Greg for roll call. We have already. Okay, do we have a motion to adopt?
So moved.
No, excuse me. Did you vote on the reasons resolution?
Yes, we voted on the reasons resolution. Now it's time to have a motion and a second on the actual ordinance adoption.
All right,
I apologize.
did you second it? Did someone second it?
I will second it.
Okay. Committee discussion, which we already had, and roll call vote, please.
Mrs. Ness?
Yes.
Mrs. Schwartz?
Under the guise of telling the rich that we've got to get them to pay their fair share, since we're dividing rich and poor here in our town all of a sudden, I am voting no.
Mr. Ritter?
Yeah, I vote no to no new taxes.
Deputy Mayor Kelly?
I vote yes.
And Mayor Salin?
Before I vote, so just want to clarify something. Rich is already paying a lot of taxes. Rich is already paying $34,000 taxes. We don't want to make it $35,000, right? So that's, or poor can't pay taxes. It's hardly paying taxes. So we don't want to increase their obligation either. So that's why I'm voting for yes. For it.
Motion passes.
Thank you. All right, so we have two more resolutions. Resolution 2019-231, authorizing the mayor and clerk to sign developers agreement with Sterling Sun at Chatham LLC, implementing planning board grant of site plan approval for Dixie Dale Farm. Al?
Yes, Mr. Mayor. As you know, this past Monday, December 16th, the planning board memorialized their approvals of the site plan for the Dixie Dale Farm development and the Arbor Green at Chatham development. That resolution is implemented through developers agreement. You can add new conditions to the resolution or to the planning board resolution, but it is implemented contractually through a development agreement. And that's what these two resolutions do. Authorizes the mayor and clerk to sign a developers agreement implementing the planning board resolutions.
Okay.
And just for further clarification, Albert, as a result of this, is Dixie Dale moving forward, or is it being held up by the court now that we've asked for an extension?
Well, at this point, the court, as I said before, has taken no action. And my recommendation to you is and has been to continue to move forward. So this is part of the continual process of Dixie Dale moving toward a final resolution along with the Arbor Green at the skate park.
All right.
Okay, do I have a motion to approve the resolution?
Procedurally, one at a time for the resolutions, or can we vote on them together?
I would vote them separate.
Yeah, one at a time. Yeah.
So
I
first up
gave
would
a
be...
general explanation.
That's 2019-231. That's what we're doing right now. Do I have a motion to approve?
So moved.
Any second? Anyone? Can I second it? Sure. I second it. All right, I second it. It's okay. So committee discussion. Roll call vote, please.
Mrs. Ness?
Yes.
Mrs. Schwartz?
Yes.
Mr. Ritter?
Yes.
Deputy Mayor Kelly?
Yes.
Mayor Salin?
Yes.
Motion passes.
Thank you. Resolution, next one is Resolution 2019-232, authorizing mayor and clerk to sign developers agreement with Southern Boulevard Urban Renewal, LLC, implementing planning board grant of site plan approval for Arbor Green at Chatham, affordable housing development at skate park.
Same explanation as before.
Okay.
So moved.
I second it. Any committee discussion? Roll call vote, please.
Mrs. Ness?
Yes.
Mrs. Schwartz?
Yes.
Mr. Ritter?
Yes.
Deputy Mayor Kelly?
Yes.
Mayor Salin?
Yes.
Motion passes.
Thank you. Now, I'm opening the floor for hearing of citizens. Any comments from anyone? Yes.
Richard Matlaga, 36 Dale Drive. One short comment. In this past week, there was an article, and Ed's not here in TAP, about that the Chatham Borough met with the Board of Education about planning for schools. I was disappointed that there wasn't representation from the Township Committee at that meeting, and I would just say in going forward, those meetings, if the borough's meeting with the Board of Education, we're all basically the same town when it comes to schools, that the Township Committee is represented when the Borough Committee is represented.
Great,
That's
thank you,
all.
Mr. Matlack.
Who's our Board of Ed rep?
Well, if I can, I just
Let
want
Bob go first, and then I can explain
Yeah.
our discussions.
I want to make sure that all of our residents know that with the discussions with the school, myself and one of our financial representatives did meet with the superintendent of schools, and we did meet with the business administrator, and we reviewed the projections that the township had for the number of students that may enter the public school system, as well as the projected costs. The superintendent and the business administrator reviewed the projected costs with us. They asked for some changes. We evaluated those changes. We made some of the changes, not all of them, but we were both the school district, from the superintendent's point of view, as well as the townships, were in general agreement for the projections as well as the costs.
And as I've stated at a previous meeting, I've met with Board President Joe Weber twice to go over, after these numbers were determined, with Bob and Mike and the business administrator, to talk a little bit about what was happening in the borough, to talk about what was happening here, whether they felt comfortable with our number, and those questions, those conversations will continue to be ongoing.
Great.
I would also like to add that I think we here in Chatham Township have shown an absolute unmitigated desire to protect our community, and we're sitting here haggling over 24 and 26 units and 70 units for a compilation of 100. And when I hear about the development in the borough, it is a whole different vernacular. And we are doing our level best to maintain our development at a slow and steady pace, to protect the rural environment of Chatham Township, and really for all of the acrimony you may see up here, we are all here to protect Chatham Township residents. And our kids go to these schools, we know that, but there is nothing more than our desire to protect our community.
Thank you, Karen. Okay, and no one else is there, then I'm closing the floor for citizens, and then we're about to adjourn. Do I have a motion
So
to
moved.
adjourn?
So moved. I do. Second.
Last meeting, done.